Okay, I'm going to try to share the screen here, and then we can get started. There we go. And pop that open. Okay. This is the patent law for physics majors presentation. Okay. Welcome to this presentation of patent law for physics majors. My name is Chris Frank, and I'm the program director here at the University of Minnesota Law School. And to begin, I'd like to give a little introduction of myself and my own experience in the field of patent law. I started out as an engineer, and I got my first job as a product development engineer at a local Fortune 500 company here in Minneapolis, and my job was to do product testing, comparing our existing product to that of the competitors. And so I did that job, and the results were quite clear. The competitors had a much better product than we had. And so I thought, this is my chance as an engineer to be an innovator, come up with the next big thing. But before I did that, I thought I should run it by my boss. And in broaching the subject, he said, no, we're not going to bother coming up with the next big thing. The current competitors are in a patent lawsuit against each other, and what we're going to do is buy the winner. So that was my first experience with patent law. And after that experience, I decided that I didn't want to work at this huge company anymore. I thought I wanted to go to the startup world where there might be more engineering opportunities for me. And I did just that and got a job at a startup medical device company and did a lot of product development work there. We went through FDA approval, the company went public, and as soon as we started selling our first product, we got sued for patent infringement. And so at this point in my 2-year engineering career, I'd had 2 huge experiences with patent law, and I decided there was something more to this than I was aware of as an undergrad in engineering, and I decided to go to law school and enter the field of patent law under essentially the theory or premise that I had come to realize that patents are the currency of innovation. If you think of a patent as a property right, then patents are something that give you the ability to charge a fee for someone to use your property or to transfer the ownership of that property in terms of a competitor that has a better performing product. And so this is kind of my viewpoint of what patents are and how they can be used to encourage innovation. So now I'm going to introduce you then to kind of a model of the world, how patents work in terms of innovation. And this is the basis of our program as well. On the bottom row, you'll see that we have these 3 different steps: innovation, patent prosecution, and value extraction. This kind of fits with our simple world view of, first we have innovation, we come up with the idea, and then we have what's called patent prosecution, which it's a misleading name. Patent prosecution, you're not in a court of law trying to put somebody in jail. Patent prosecution refers to the act of drafting patent applications, so covering the invention by patenting it. So we come up with the idea under the innovation block, and then we protect the idea by patenting it. And then that 3rd step on the bottom row is value extraction, where what we do is to try to create money from that patent or that innovation. And we can do this in a number of ways. The simplest old-fashioned way is to make a product and sell it. Another way, a more modern way, is to license the technology to another organization who then goes and sells it and pays you a royalty fee in exchange for the use of your invention. And third is you can sue someone for patent infringement. So different ways to extract value from this technology. And then above that, we have kind of a catch-all, which we call portfolio management, because this simple model of come up with an idea, patent it, and make money from it, it doesn't usually work that way. It's not always that simple. Most products are the result of hundreds, if not thousands, of different ideas, some of them patented, some of them not. And so we have to make a decision about which ideas to patent, which ones not, and how we're going to make money. Some things we might license and others we might not, and so on. So we have this whole concept of patent portfolio management. For example, the iPhone has something like 20,000 patents behind it and counting. So there's not just this one-to-one ratio of an invention to a product. A product can be thousands of patents. Okay. So with that in mind, this field of patent law then is representing a huge opportunity for people with a technical background that want to work in this area. What I have here is a graph of the number of new US patent applications, and you can see that it is rising at a very fast rate. And then on the bottom, we have a graph of the number of new patent bar members entering the field each year. And you can see that that is actually a slowly declining line. So the gap between the number of new US patent applications and the number of new people entering the field is growing, and what we call an opportunity gap, meaning we need more people to write more patents. Okay? So where have all the patent lawyers gone? So generally we thought of this as a field that is entered into by someone with a full 3-year law degree. However, the people going to law school has dropped off significantly, and in particular, people with technical backgrounds are not going to law school. By 2018, according to this study, the number of new entrants to the patent bar is expected to shrink to less than half of what it is today. And that would put it at, it's generally been around 1,200 new people per year. It's looking at going down to around 600 people per year, while the amount of patent applications filed will continue to rise. Okay? So with that in mind, we ask the question, don't I have to be a patent attorney to work in the world of patents? And the answer, surprisingly to most people, is no, you don't have to be a patent attorney. You can be what's called a patent agent. A patent attorney is someone with a science or engineering degree plus a law degree, and they pass the state bar exam plus the patent bar exam. A patent agent is someone with a science or engineering degree that has just passed the patent bar exam. The patent bar exam is a 100-question exam offered by the US Patent and Trademark Office. So a lot of engineers mid-career will turn into this career of being a patent agent and start drafting patents or managing patent portfolios and that sort of a thing. So the question that generally rises after that, how come I've never heard of a patent agent before? And the reason is there used to be enough patent attorneys in the field to do all of the patent work, and so therefore the only people that became patent agents were engineers that were 15 or 20 years into their career and discovered that this opportunity was available. But now, because the demand is there for people with a patent background and there aren't enough patent attorneys, there is now this opportunity for people to choose the patent agent career as a career option, as opposed to something that they stumble upon some years later into their career. Okay, so the Master of Science in Patent Law, that is where we come in. We're training you not to be a patent attorney, but we're training you to be a patent agent. And while there are some things that a patent agent does that are identical to what a patent attorney does, there are other things that a patent agent does that patent attorneys do not do. It is a different career path. So patent prosecution, as we talked about earlier, is the art of drafting patent applications for inventors. A patent agent can do the exact same job as a patent attorney. You can have your own clients, you can hang up your own shingle and write patents for inventors and companies and corporations and so on. You're not an assistant, you're the exact same level of ability as a patent attorney. You can work at a law firm with patent attorneys doing the same work as patent attorneys without having to go to law school. Now, the next couple things in the list are different. A patent attorney, other job responsibilities or employment opportunities are going to relate more to the legal aspects of patent law, drafting legal agreements, legal opinions, and litigation. A patent agent will be more on the business side of things, doing patent research, patent portfolio management, and innovation. So it is a identical career path in terms of drafting patents, and then it's a separate career path more focused on business for the patent agent and more focused on the legal aspects if you're a patent attorney. We'll go into these more in a little bit more detail at the end when we have a little bit more background in patent law. But just to illustrate this difference, Apple, because everyone's heard of this company before, Apple has posted a position, I guess it was about a year ago now, where they wanted a patent/technology analyst. And they specifically said in there, quote, patent lawyers who prefer to focus on the technological aspects of patents rather than the practice of patent law will be considered. But this is a non-lawyer position. So in other words, there are positions out there for patent agents, non-lawyers that work in the field of patent law. Apple having one example where they were very explicit that apparently it must be confusing to not only non-lawyers but also to existing patent lawyers about the distinction between these positions. So here are some other opportunities where they were looking for patent agents or non-lawyers in this field. You can see there are pharmaceutical companies, food companies, tech companies, Avery Dennison, the label maker company, and so on. Additionally, here's a number of law firms that were looking not for patent attorneys, but for patent agents. So keeping this in mind, this is why there is an opportunity for people in this field. When we say opportunity, the first thing that comes to mind is how much will I get paid? Because it's generally been a career stumbled upon by engineers, mid-career engineers, there's not a ton of salary information out there, but these numbers will give you some ballpark figures. If you're going to work at a corporation, you're going to get paid a little bit less than a law firm, but you're not going to have to bill the longer hours. I would say now, having been through this program for 1 year, depending on your degree, your salary is going to go up or down, but starting with a bachelor's degree in science, you're looking at about a floor of $70,000. And as you have a more advanced degree or a degree in electrical engineering, computer science, physics, then you start getting into the 80 and maybe even the $90,000 range, depending if you're working at a corporation or a law firm. So those are kind of the opportunities that are out there. This is the opportunity gap. The gap is real. They cannot find enough people to fill these patent roles, particularly if you have a background in physics, electrical engineering, or computer science. Okay, so let's talk about, if you're interested in pursuing this career or finding out more about it, we're going to give you some basics in patent law, the patent process, and then kind of a day in the life of these different career opportunities that our program prepares you for. So first of all, patent law in general. What is a patent? What's it take to get one? Patents exist because of our United States Constitution, that in order to promote the progress of science and the useful arts, by securing for limited times to authors and inventors the exclusive right to their respective writings and discoveries. So what we are trying to do in patent law is to give a monopoly to an inventor in exchange for that inventor teaching us how to make and use their invention, writing in explicit detail how to make and use their invention, with the hopes that then the rest of us can read that patent application and improve upon it. So it's supposed to encourage innovation by, instead of keeping something a secret, you tell the world how you did it so that the world can then continue to build on it and improve upon it. Now, does it actually work that way or not? We're not going to get into that philosophical question at the moment. We're just going to accept that the patent system exists, and this was the original reason for its existence. Okay, patent law basics. Just to make sure that we are in the right room, there are generally 3 areas of intellectual property law: copyrights, patents, and trademarks. And the media gets this wrong a lot of times, so we want to make sure that we define our terms properly. Copyrights refer to artistic works of expression, so a musical song, a play, a musical play, things like that. Artistic works fall under the area of copyright law. Trademarks refer to business names and slogans. The Nike swoosh, 3M, and Motorola, things like that are trademarks. And then patents are what we think of when we refer to technological inventions and innovations. The media will get this wrong. They will say that so-and-so has patented the song or patented a catchphrase. We just have to live with it. But we're talking about patents today. We are talking about technological inventions. Okay, so patent law basics. A patent, in order to be allowed, has to have essentially these 3 things. It has to have utility, which means it must be useful. It has to have novelty, which means it must be new. And it must be non-obvious, which means it can't be just an obvious change or an obvious improvement to an existing idea. So what I'm going to show you really quickly here are kind of what these three terms mean in terms of getting something patented and protected. So when we first talk about utility, we talk about usefulness. How useful does an invention have to be in order to afford patent protection? And here is an actual US patent, a method for exercising a cat. So if you want to kind of imagine a scale of usefulness, what this person's done is they've taken a laser pointer, they point it around the room and have their cat chase after it. Not the most useful thing in the world, but nonetheless useful enough to be a patent. Okay, and let's look at another example. This is the most cringeworthy patent ever. It is an apparatus for facilitating the birth of a child by centrifugal force. So there is a woman put on a machine that provides centrifugal force and then an appropriately placed net to catch a baby. That is, as I said, it's cringeworthy, and but somehow this was patented back in 1965. And once again, is that very useful? Probably not. And last but not least, just to erase that last one from your memory, here's another actual US patent. It is a fantasy football system. So how useful does something have to be in order to be afforded patent protection? If we think of this as a hurdle, it's a very low hurdle, minimally useful for its intended purpose. But that's not the only requirement for a patent. So let's look at our next hurdle, and it is novelty. How new does an invention have to be? So here's an actual US patent on coffee cup sleeves. And back in 1993, this patent was issued. It was a coffee cup sleeve having a number of kind of corrugated, elongate ridges. And then someone came along a few years later in the year 2000 and replaced those ridges with a number of dimples. That was a new enough improvement to get patent protection. And finally, in 2013, someone came up with the idea of, instead of having ridges or dimples, to have this little tab at the top of the coffee cup sleeve. And this tab allows you to not squeeze the coffee cup so hard and therefore use gravity instead, so you don't have to burn your fingers by grabbing too hard. So those are very simple improvement inventions, and they were all patented. So when we ask the question, how new does something have to be in order to be patented? It doesn't have to be all that new. It just has to have some sliver of newness. Something about it has to be different than what's already out there. So finally, we come to the last question, the last hurdle. The first two look fairly low. It has to be useful. It has to be new. But the question next is, can the idea be an obvious change or not? And if not, how obvious can it, or non-obvious must it be? And the trick to this, and this is where the money is made in the world of patent law, is understanding this concept. The question of obviousness is whether or not this new change would have been obvious to a person of ordinary skill in the art at the time that the invention was made. So we call, even though we're talking about technology here, they refer to the technologies as art. So the art of coffee cup sleeves. A person of ordinary skill in the art of coffee cup sleeves at the time the invention was made, would they or would they not have thought that those tabs were an obvious improvement, is the question that we are asking. And this is a very, very kind of abstract concept. When you're talking with the patent office about whether or not a patent's going to be allowed, you and the patent office are arguing about this imaginary person of ordinary skill in the art and whether or not they would have thought at the time of the invention to make this change or not. So you're talking about a medical device, you're talking about a consumer electronic, whatever the case may be. We have this imaginary person of ordinary skill in the art, and whether or not that person would have thought it was obvious. And this person of ordinary skill in the art is thought to have essentially read every patent and every website and every product that's already out there. So they're somewhat of a speed reader, but they have access to no confidential information. So they don't work at a company where they have like business strategy plans and that sort of thing. It's a very, as I said, abstract concept. Now let me show you how hard it is sometimes to decide whether or not something is or is not obvious with a fairly simple invention. So I have here the invention of rolling luggage. Someone took the idea of the suitcase and decided, why carry this thing when I can just use this invention of the wheel and put a little tethered handle and pull it along. So this idea came out in 1972, and actually it did not sell very well because they put the tiny little pea-sized wheels on the bottom and a flexible handle. So if you went too fast, it would fall over. If you turned a corner, it would fall over. It was not a very good product. Good idea, bad product. So eventually, as we all know, someone came along, perfected this invention. They turned the wheelbase 90 degrees, so you have a wider base, used larger wheels and a rigid handle so that you can turn corners and go fast and it doesn't fall over. Now, here's what's amazing about these two ideas. It's not rocket science. The first idea for luggage on wheels came out in 1972, and the perfected idea did not come out for another almost 20 years, 1989. In that time, 4 billion people traveled on the airlines. Some 20 years after we landed on the moon, we perfected the wheel on luggage. So something that seems obvious in hindsight is not that simple, not that easy, not that obvious. So, oftentimes we hear people complain about the patent office allowing these simple, obvious, what people call obvious changes, when the fact of the matter is a lot of these seemingly obvious changes are not that obvious when you try to actually do it in the real world. People miss these opportunities more often than not. Okay, so that's our basics of patent law. Invention must be useful, new, and not obvious. So, with that knowledge, we're going to walk you through the patent process. Now we know what it takes to get a patent. Now, what is that process of applying for a patent with the patent office and getting the patent? I'm going to use this patent here of the cheese crust pizza. Can you really patent a pizza? So once again, first of all, it has to be useful. Is pizza useful? Yes, incredibly useful. It keeps us, fills us with the nutrients that only pizza has. And so the question then, is it new and is it a non-obvious invention in terms of patent law? So the patent process looks a little something like this. We start with our idea. In this case, it was an 18-year-old Italian kid that had come up with this idea of the cheese crust pizza while cooking for his girlfriend, and he thought that he had such a great idea that he would consider patenting it. So you have your idea, and you might develop it a little bit. What kind of fillings should I put in this cheese crust, in this crust, etc. And then you go and talk to your patent agent or a patent attorney. So now imagine if you want to pursue this career in patent law, you would be the patent agent that this inventor would come to with this great idea. And they would say, I want to patent my idea on the cheese crust pizza. So what you would first do is perform a patent search to see what's already out there to make sure the idea is actually new. And here's what you would have found at that time. There was a donut-shaped pizza that had a hollow center. And then there was also kind of a pizza pocket pizza that had basically a pizza crust covering over the entire thing, but nothing identical. So our idea is new enough that we think that we can file a patent on the idea. So that's what we do. We perform a patent search, then we file a patent application. What does a patent application look like? This is something that you could actually be drafting if you decide to pursue this career in patent law. Here's what the cheese crust patent application looked like. We have a bunch of drawings of how to make that, and then we have a written description teaching the world how to make and use it. And then at the very end of the patent application, we have what are called the patent claims. And so the reason that we refer to this field as patent law is that each of these claims is a single sentence long that essentially becomes a law, that no one in the United States can make, use, or sell an invention that fits this description. And so you're going to carefully word each of these claims, each of these sentences, to make them as broad as possible to prevent others from copying your idea. To visualize it, it can look something like this. The claim in the middle is the sentence, and I'm trying to craft this sentence as broadly as possible without covering anything that already exists, that's already out there in terms of what we found in our search. And so literally you can decide, what I would tell clients when I was practicing in this area is I literally would spend, if I'm going to spend 20 hours writing a patent application, I would spend 5 to 10 hours just writing this one sentence, this claim, trying to decide, should I call it a food layer or a cheese layer or a tomato sauce layer? If I call it a tomato sauce layer and somebody makes a pizza without tomato sauce, are they still infringing on my patent or not? That's going to determine whether I'm going to use that term or not. Should I call it a slice of pizza or a piece of pizza? Does that matter? I don't know. I have to think about it. So literally, because this is going to be a law, and you're going to have to, it's going to define the rights of your patent application, you are going to take every care that you can with your word choice. Once you've done that, you're going to file your patent application with the U.S. Patent Office, and you're going to have patent pending status. You still don't have an actual patent yet. You have patent pending. It has not been yet granted, though, for your invention. And you're going to wait and wait for a long time before you hear back about the status of your patent, generally 2 to 3 years before you hear back from the Patent Office. So you have this 2 to 3 year period after you file where you literally don't know if you're going to get a patent yet. Because we're dealing with a government entity, they're behind, they're backed up, and it just takes them that long to process these inventions. Finally, you're going to hear back, you're going to get a first office action. The Patent Office does its own patent search, and they'll either reject your claims or allow your claims. You then have the opportunity to amend them. You can make them narrower so they get allowed, or you can argue that the Patent Office is wrong and have them change their mind and get a patent allowed that way. And then you get a second office action, depending if you made amendments and they allow your patent and that sort of thing. And finally, the patent will issue. Now you have an actual U.S. patent. Here's what you get. You get patent protection for 20 years from the date of filing. No one in the United States can make, use, or sell the invention that you have claimed in your patent. So now I've talked about these claims a little bit here. Now we're going to look at what the actual patent claim looks like. So once again, this is a law, basically. No one can make or use or sell a pizza that fits the description of this claim. So now I've bold-faced a few phrases here because this is going to be important for, when we talk about patent law here. As you'll see under paragraph B, placing a plurality of separated individual food portions on the dough base. So in drafting a claim of this pizza, stuffed crust pizza, they have written in a requirement that there are a plurality of separated individual food portions. So instead of having a continuous cheese crust, they have decided to make a plurality of separate cheese crust portions. And I think that you probably see where I'm going with this. Someday in 1987, this patent was issued. In 1995, Pizza Hut debuted the stuffed crust pizza, but it was a continuous stuffed crust as opposed to a plurality, more than one, food portions that were stuffed. Pizza Hut increased their sales by $300 million in the first year. Our inventor saw this Pizza Hut idea. They had actually contacted Pizza Hut some years earlier about the idea. Pizza Hut turned them down. The inventor sued Pizza Hut for patent infringement and lost because the specific language of their claims required a plurality of food portions, and Pizza Hut did not have a plurality of food portions. They had a single continuous food portion. So words matter. How you describe your invention, what you're trying to protect, is going to determine what kind of monetary value you can extract from that idea. And this is why there's a demand for patent practitioners, because of the importance of these patent applications, the wording, and everything that goes into them. Okay, that is the summary of patent law in general. Now I'm going to kind of walk you through a day in the life and the different kind of career paths and career opportunities in patent law. The first one we're going to talk about is innovation. Using patents to come up with the next big thing is what the patent system was actually created for. So oftentimes what you'll find is people have ideas and what they wonder is it a good idea or not? What I'm going to give you here is kind of just a simple way to look at ideas and innovation. What I have here is the innovation equation. If you want to increase your innovation, you can either increase the benefits or decrease the efforts, or both, and you're going to increase the amount of innovation. So I'm going to show you a couple of examples here. So for example, the light bulb. The light bulb offers us a big benefit. We can illuminate the entire room or a home or whatever the case may be, and it requires a very small effort. All it takes is a flip of a switch. Big benefit, illuminate the room. Tiny effort, flip a switch. So easy that we just do it for fun, right? So that's one example of the innovation equation. The automobile is another example. Big benefit, 60 miles per hour. You can take this heavy piece of metal and machinery and accelerate it from 0 to 60 miles per hour in a matter of seconds. And the effort it takes to do that amazing thing, is merely changing the angle of your foot, pushing that pedal a little bit, and you're accelerating this giant piece of machinery to 60 miles per hour. Big benefit, small effort. Facebook is another example. The big benefit is you're able to stay connected with friends and family. And the effort, you don't have to call them. You don't have to send them a letter. You don't have to decide what are you going to say to them when you see them. All you have to do is scroll through the status updates and get that benefit of what everyone is up to. Great benefit, tiny effort. The opposite of this is what we call the Rube Goldberg inventions. So I once had a car with a coffee cup holder, and the way that the coffee cup holder worked is you had to flip down the armrest, open up the armrest, flip out the coffee cup holder that had these little springs in it, and then finally, after these 25 steps, you could put your cup into the cup holder. So it gave me a very small benefit, a thing to hold my coffee cup in while I drive. And it required a large amount of effort. I had to put the arm down, open the armrest, swing the holder out, etc. It was as though a physics major took, because I know I'm talking to physics majors here, a physics major tried to apply every concept of mechanics and dynamics in order to create the ultimate coffee cup holder Rube Goldberg machine. So that is the opposite of most of our innovation equations. So in the day in the life of an innovator, you're thinking about this equation and trying to make greater benefits and lesser efforts to achieve those benefits in the world of innovation. Okay, next one, a day in the life, patent prosecution. What you'll be doing if you're a patent prosecutor, once again, you're the person who's writing these patent applications. You're writing those claims for the invention of the cheese crust pizza patent. You're going to new inventor meetings, you're writing applications, responding to the office actions from the patent office, and other patent practice issues such as, are we infringing on anybody else, and that sort of thing. Now, in this case, you're doing the exact same job as a patent attorney. You are just called a different thing. You're called a patent agent. Same job. Next one, day in the life, patent portfolio management. In this role, it's more usually in a corporation. In a research type of role, you'll research to see if an idea is patentable. You'll hold patent review boards where a team of maybe marketers and technical people and some business people will decide whether or not each idea should or should not be patented. You might also do some patent analysis and strategy. What are the competitors up to? What patents have they been filing? And also holding brainstorming sessions of coming up with actual ideas when you identify opportunities for innovation. Next one, a day in the life, value extraction. So a lot of these tech transfer positions at universities and that sort of thing, where you take existing university patents and try to license them to existing companies. So in this case, you'd be going to trade shows, evaluating patent portfolios, and looking for companies that are potential partners. So that's kind of the different career opportunities, innovation, patent prosecution, tech transfer, and portfolio management. So 4 kind of different career opportunities that you can do and that our program prepares you for. Okay, so now about the program, the last few minutes here. Are we taking the applications for fall 2015? Yes, we are, and we are offering scholarships, and we look forward to seeing your application. Here's what you would be in for if you apply. It's a 1-year program, 1-year Master of Science in Patent Law program. At the end of this program, you will have completed courses in patent law, patent prosecution, those 4, the big components we showed you, portfolio management, and patent transactions. You will create essentially an entire portfolio of work in the patent field that you'll be able to show potential employers. And also, we include with our tuition a patent bar review course so that you'll be able to pass that patent bar. It's very difficult exam. It has something like a 30 to 50% pass rate, but if you take the patent review course, you have about a 90% pass rate. So we include a patent bar review course so that you become a patent agent as well. And as I mentioned, if you're a major in electrical engineering, physics, or computer science, these are the 3 highest demand areas right now. You will be an ideal candidate for many different opportunities in the field of patent law. Just an overview of these courses. You are taking the same courses that law students, JD students, are taking for the most part, and you are going to be taking more of them more in depth. And so therefore you are going to be well prepared for a career in this field, depending on whatever path you may choose. Who is this program for? The most common thing we hear about people interested in this program is they like science and technology, but they don't want to work in a lab. So if you're considering law school, but you don't want to invest 3 years, this is a great opportunity. Who is our ideal candidate? If you have the interest and capacity in learning a wide range of new technologies, this is then a pretty fascinating field. You get to see inventors and corporations of all shapes and sizes. We're looking for people with strong technical writing skills and an interest in developing those skills, strong analytical abilities, and an interest in developing those abilities. Key benefits of our program, I mentioned a few of these already. You're taking patent law courses with JD students. You're learning from leading patent practitioners. You're getting the practical skills. Like I said, you're creating an entire portfolio of work. It's a practical work that you're doing to show to potential employers. And you're getting exposure to a wide range of perspectives in patent law, areas of practice, and opportunities. How to apply: a statement of interest, a letter of reference, transcripts, a resume, and then a GRE or LSAT score is optional. We don't require that, but if you want to send that in, that's optional as well. If you have any questions, feel free to contact me, patlaw@umn.edu. As I said, we are accepting applications for fall 2015, and we are looking for physics majors, and we are offering scholarships. So please feel free to contact me with any questions, and thank you very much for your time.